In this video, we'll talk about sorting and selecting authority once you've done a thorough job of researching your issue. So first we're going to talk about the goal for sorting and selecting your authority, and then we'll talk about a method for sorting and selecting your authority. So the goal for sorting and selecting. You want to come up with a stack or a list of authority that you can use to start the analysis process with. Remember that on your bench memo, you were given a set of cases and then you just started the process from there. Here, you're going to have to do all of the original research for the strategy memo and then whittle down that list and then start the analytical process. So you're doing the entire process from start to finish. So you'll have to find those cases that you start the analytical process with. You'll do further weeding out when you decide later what you want to use to support your analysis in your explanation paragraphs. So you're going to start out like you did in the bench memo with a set of cases. Now, you started out with fewer than 5 cases for your bench memo, but you may start out with a list that's much, much longer than that as you start your analytical process. So as you begin the analytical process, you're going to weed out a lot of cases just like you did in the bench memo. So you synthesized or you created a synthesis chart for all of the cases that you had on a particular issue, and then using that chart to draft your explanation paragraphs or to plan your explanation paragraphs, you ended up weeding out some cases. It's going to be the same way here. So you'll start out with a long list, and as you get into the analytical part of the process where you are placing cases in a synthesis chart, you'll start to weed through what you actually want to use in your explanation. Now, for the bench memo, you did a synthesis chart for the sole purpose of synthesizing a rule. For your strategy memo, you may or may not need a synthesized rule. It could be that all of the rules are available to you as express rules in statutes and case law. However, I still encourage you to draft a synthesis chart so that you have a catalog of all the cases that will help you choose which ones are best for your explanation and application. So those are your goals for sorting. Here's the method that you're going to use for sorting. First of all, you're going to determine what's binding. And so anything that involves the same law and the same jurisdiction on similar facts, not identical facts, but similar facts, is going to be binding. So same law, same jurisdiction. Then you're going to take a look at what's sufficiently persuasive to use. And so you want a hierarchy of what's the most persuasive down to what's the least persuasive so that you can make these decisions about which one to choose. So the most persuasive authority is going to be same law, different jurisdiction. So let's say, for example, a New Jersey interpretation of a New York law. Or even, let's say, a different trial court's interpretation of the same law. So if it's the same law, but just determined by a different jurisdiction, then that's going to be persuasive. If it's different law in the same jurisdiction, that's going to be persuasive, but not as persuasive as an interpretation of the same law. Although sometimes these run neck and neck. So for example, let's say you have an interpretation of a different statute by the Court of Appeals, but on a similar issue. So let's say, for example, arson and burglary are similar crimes in that they both involve some sort of entry or destruction to a building. And so the courts will talk a lot about the characteristics of a building that make a crime burglary or arson. So let's say you're analyzing a burglary case, but you have an arson case that discusses characteristics of a building. Well, that won't necessarily be binding if they're discussing the arson statute rather than the burglary statute, but it will be very persuasive. What the court finds to be a building for one purpose, they may very well find to be a building for another purpose, so long as the same policy considerations are at stake. So it's still going to be persuasive, but it's just not going to be binding. Next, you have different law, different jurisdiction. So let's say that you have an arson case from Connecticut, and your case is a burglary case in New York. That arson case in Connecticut that discusses the qualities of a building is going to be persuasive, but not as persuasive as if you had a New York interpretation of building under burglary, or even a New York interpretation of building under arson. And then finally, there's really everything else. Secondary sources or anything else fall after that. You're going to weed out any secondary sources that you use to get background into your topic that aren't directly relevant to resolving your issue, but that you just use for background. So for example, you're never going to cite an encyclopedia, you're never going to cite a treatise, you're very, very rarely going to cite an ALR. I mean, you should really, really not have much else to go with before you cite an ALR. And then sometimes you'll cite law review articles depending on the author. To determine whether or not you should use a secondary source as one of the citing sources in your document, what you want to do is shepherdize that source so that you can see if courts are citing that source. If courts are citing that source, you can feel more comfortable citing it. But again, remember, courts can do things that we can't. They're the courts, we're the advocates. And so just because one or two courts have cited it doesn't necessarily mean you should cite it. But if a lot of courts are citing it, you can go ahead and do that. So for example, the restatement of torts. Lots of courts cite that. And so the restatement might be very persuasive authority. So that's how you sort your authority. You're going to sort it into these different piles. You're going to have binding, and then you're going to have a pile for same jurisdiction, different law, different jurisdiction, same law, and different jurisdiction, different law, and then finally a pile way over to the side with all of your secondary sources. The taller your binding pile is, the less likely you're going to have to dip into these other piles. So first you sort them out, then you're going to select. Again, having a synthesis chart for your binding cases is going to really help you select which ones you want to cite. So after you've already whittled it down to only relevant authority worth citing, you've got it in those piles, and you've decided these are the things that I might want to cite at some point, and then these are things I'm never going to cite. If you decide you're never going to cite something, pile those up on one side along with your secondary sources, put them off to the side. Don't throw them away yet. You never know when you might want to dip back in there, but go ahead and put them off to the side. You're probably done with those. So for your rule thesis sentences, ideally you want something that is binding. You need something binding for your rule thesis sentences. Then you're going to look for cases that will help you with your explanation and application. Which cases are factually similar enough that you want to use those to make comparisons and distinctions. Now, you want to remember that both parties might rely more heavily on each party may rely more heavily on a different case. And so you want to make sure you explain all of the cases, the ones that the prosecution or the plaintiff will use, as well as the ones that the defense will use, and then show how both parties would deal with all of the relevant cases. So once you've chosen binding authority, if you've got it, for your rule thesis sentences, you can use different cases for your explanation if you want. So for example, in an explanation paragraph, your first sentence would need to be cited to binding authority, your rule thesis. But then the facts, rationale, and holding can come from a persuasive case as long as they're consistent with the binding case that you cited for your rule thesis sentence. Just because you've cited something for your rule thesis sentence doesn't mean you have to use that case for your explanation. You can use a different case for your explanation. Likewise, just because you've cited cases for rules in your roadmap paragraphs doesn't mean you have to use those same rules, those same cases for the explanation. You're citing for two different purposes. In a roadmap or in a rule thesis sentence, you want to make sure you've got binding authority as long as it's available, because you're citing the law, the rule. So you want to make sure you've cited binding authority for the rule. However, for the explanation, you're just illustrating the rule. So as long as it's an illustration of the same rule, it can be persuasive authority. Again, if you've got binding authority, you definitely want to use that for the explanation. But if you don't, you can rely on something persuasive. Okay, so these are additional principles that come from that article, The Art of Selecting Cases to Cite. If you haven't read that yet, that's an incredibly important article for you to read before you try to decide which cases you want to use. And so these principles, basically, these items just summarize what's in The Art of Selecting Cases to Cite. Okay. As you go through this process and as you begin writing, you may discover that you have a gap in your analysis as you start to write, and that you want case law or some other authority to fill that gap. Be open to the idea that you may need to go back and do some gap filler research after you even start writing. Because remember, this isn't really a linear process. The process of research can be sort of a spiral process where you sort of go down in circles even as you're making progress. And likewise, moving from research to writing is not a strictly linear process. There's not a strict dividing line between research and writing. Having said that, you all have individual strengths and weaknesses with regard to researching and writing. If you're a stronger researcher, you may need less time for that research process, but you may need more time for the writing process. If you're a stronger writer, you may need more time for researching and less time for writing. So don't worry about what your classmates are doing with regard to where they are in the process compared to where you are in the process. You're going to have different needs. What you want to make sure you do is plan your time out so that you have enough time for to take advantage of your strengths and to compensate for your weaknesses. So that's it on sorting and selecting authority. The next thing that you're going to do is to prep for class. You're going to do exercises 8A, 8B, and 8C in Newman. You'll do those alone, and then when we get into class, you'll compare notes with your group, and we'll go over those. And then after this class, where we talk about those exercises, 8A through 8C, now things are going to move very quickly toward the finish line for the course. When you've completed this process of sorting and selecting, you're ready to start the analysis. And so this list just tells you, it just reminds you what all the steps were that you went through to draft your bench memo. So you're going to go through those same steps. So go back to the beginning of the course. Use your notes as you write this strategy memo. Once you finish the research and you're satisfied with that, that you've done all you can do so far for that process, go back to your notes from the beginning, because now you're going to start with the rules. What are the rules? How do the rules break down? Which elements are at issue? And then you're going to carry that through to synthesizing any needed rules, and then you're going to move into choosing cases for explanation and application, and then into the drafting. And so you're going to put that entire process together. So don't forget everything that you have done thus far. So before you draft, you want to verify your authority, and that is the next step that we're going to take. And then you'll be done with the research completely and ready to start analyzing and drafting.